welcome to our Trade Secrets Institute program. You're in for a real treat. You know, it's a cliche to say that the world is a global village and that law is increasingly international. But certainly we feel that here at this law school. Next week we're sending off one of our professors at the invitation of major law schools in India to talk about studying law here. Great interest. And it turns out that we have great connections there, and they have a great appreciation for our law school. But then sometimes that connectivity pops up in unexpected ways. So, for example, this morning, I have called to my attention the article or posting that if you do the Chinese equivalent of Google, Baidu, about Brooklyn Law School, apparently the Chinese version says something like, Brooklyn Law School has 5 faculty members, no particular campus, is not authorized to grant degrees, and so on and so forth. And we're finally figuring out that they were doing a bad translation of the history of Brooklyn Law School and didn't get past 1901. So we're kind of trying to figure that out. I'm sensitive to this because recently there was an article in China GQ about me. I was very pleased with the concept. And I thought this was extremely cool. They had a picture of me and all that. First thing I noticed was the picture was awful. I looked like Jabba the Hutt, which increasingly I do. Thanks to all the good food. I hope some of you enjoyed that around here. And so I called up the editor and kind of gave him hell. And I said, look, this is you were over at my office. You took 200 pictures, and you picked this one. It looks like something in the Macy's Day Parade. They're carrying down, Fifth Avenue. And he says, no, in China, looking prosperous like that is something that draws a lot of respect and admiration. I said, now you made me feel awful because you're not denying it, So then somebody said, well, you want us to translate the article? And I said, no, absolutely not. I want to tell everybody it means I'm the most charismatic, effective, leader in the law and so on and so forth. But unfortunately, some wise guy did translate it. And apparently, they're not that great with colloquialisms, and they wanted to say I was the big cheese, and they said I was the big potato. So there's always those kind of issues. Recently, David Mitnick knows this. Some of you know this. Those that are on our faculty and adjunct faculty were here for a professional development session that we had, and I couldn't be there because I was in Russia. And I was invited to speak about, again, why study law to these hundreds and hundreds of university students who are considering becoming lawyers and maybe even coming to the United States. And so I chose to speak about the reasons for studying law is to learn the language of liberty. And if you want to be a peacemaker, study law. If you want to, you can figure it out. And if you want to be a champion for justice, study law, and so on. And on the way out, we touched in, the way out of the country, we touched down in Zurich, and my wife Marla said, it's a good thing we got out of the country before they translated that speech. But they were very, very receptive to it. The Trade Secrets Institute is one of the aspects at Brooklyn Law School where we are uniquely involved in international matters and national matters because intellectual property is the issue of the day, and it's an issue that crosses these increasingly porous borders. We're dealing with all these topics that you all know about and live every day, of cybercrime, cyber hacking, cloud security, all of this and what it means for traditional concepts of trade secrets. And it's critical, the level of industrial espionage and economic espionage is gigantic. And it's a real issue that touches the core of not only economic security, but national security, and not just for the United States. So the topics of this institute You know, who knew? You guys are sexy. I mean, it's really cutting edge stuff. We're very, very grateful for the support of the May Foundation that makes this all possible, for the leadership of our great alum, our great former faculty member, the great Judge Claire Kelly, who has been a leader in a moving force. She sends her regrets. She's on the bench today, had hoped to be here, but is unable to do so. David Mitnick and Alex Kaplan, both of the great class of Artiot. They're true millennials. Or the end of the last century or the beginning of the first century, I don't know. Maybe you're old millennials, right? Both, okay. They have been instrumental in moving this Trade Institute forward, and we're very, very grateful to them, and also grateful to our incomparable Professor Beecham, who has a great book coming out. And it's, yeah, and copies will be available. And the topic is on patent. It's a
invented by law. It's telling the history of patent law through Alexander Graham Bell's famous telephone patent on the shelves in the basement, for example.
In time for Christmas is it's a great stocking stuffer and door stopper. It's not a little book. It's a, yeah, but it's a great read. It's a great read. Great stories there. Who knew? But it's tremendous. And the program here is one that the law school is not only servicing and connecting our students and our faculty with what's going on in practice, but it's an example, as I was suggesting, of the law school reaching out and connecting throughout the United States and abroad. We're also fortunate, you know, 2 years ago I said at the alumni gathering, I said, our aspiration is not to be better. And then I paused and everybody looked at me like I was suddenly breaking wind or something. And then I explained that our aspiration is to be truly the best in what we can be best in. And this is an area that really not only fits us, but also it reinforces another major initiative that we have here, CUBE, the Center for Urban Business Entrepreneurship. It's a natural fit. And CUBE, I think, in its interplay, helps reinforce and advance the interests of Trade Secrets Institute. And so this is something that really fits our platform here. Paul Gangsey, who's our director of CUBE, is here. If those of you who don't know him, you should get to know him. He's a phenomenal addition to our faculty and to the program here. Our students are very much engaged and by the way, I see our newest member of the faculty, intellectual property, Christina Mulligan. You should all get to know her. I don't even ask her anymore. I just send students her way. You know, back in the Middle Ages when I was clerking, I clerked with a person who's now professor at the University of Michigan University Law School, Rebecca Eisenberg, and she just last night sent me, you know, rave reviews about your performance at Michigan State. Said not only do you give good paper, but you give good comments, and so that was really phenomenal. So good for you. I'm very proud to hear about those reports about you. Today's symposium also could not have happened without the work of three of our students, Alexandra Kalika, Paul Frollo, and Dia Liu. And Paul, I understand that you sent out very rigorous materials last night. We're going to see if this first panel is up to the game. So it should be a great day. We thank all of our staff, in particular Liz Alper, who's in the back of the room. She's often the unsung hero in all of this kind of event, and looking forward to you having a great session for the rest of the afternoon. Thank you very much for coming. Bye-bye.
Thank you, Dean Allard, and thanks again for everyone for joining us this afternoon. My name is Alexandra Kaleka, and I'm one of the Trade Secrets Fellows this year. On behalf of myself and the two fellows that will be moderating the panels momentarily, we would like to thank you and welcome you to our symposium, Trade Secrets Law at the Edge. The mission of the Institute, as well as the goal of this symposium, is to explore what makes trade secret protection increasingly relevant, as well as at the edge of the law. We seek to provide a comprehensive overview of all key cases and initiatives throughout the United States, as well as different updates and whatnot, excuse me. with our database on the website, which is actually the first of its kind in the nation to connect users and practitioners to all things trade secret. Currently, the law stands at the brink of reform in Congress. As you will soon hear, the Defend Trade Secrets Act could lead to the possibility of a civil cause of action in federal court. Additionally, trade secret protection plays an important role at the edge of innovation for entrepreneurs and new businesses alike. Thanks in part to recent changes in patent law, which we will hear about later, trade secrets has never been more important to the emerging innovative economy. The first panel will now begin, followed by question and answer and a 20-minute break. So I will leave it to Paul. Thanks again for joining us, and we hope you find it interesting and informative.
So my name's Paul, and we're joined today by Ted Schroeder, who is the Chief Counsel to Senator Coons, who co-sponsored the Defend Trade Secrets Act, or the DTSA, as we'll probably be referring to it, along with Senator Hatch, and Professor Christopher Seaman of Washington and Lee Law School, who authored the article, The Case Against Federalizing Trade Secrecy, and Ira Levy, who's a partner at Goodwin Procter, a Brooklyn Law School alumnus, and he has a great deal of practical experience in IP. So I'll turn to you guys. I'll open it up for initial comments. If you could tell us a little bit about your experience and background in trade secrets, and also if you could just give us a brief background on kind of what is a trade secret, why is it important, and what is the current state of the federal legislation?
You want to go first?
Sure.
I want to say thank you very much to Dean Aller and Professor Buchan and Brooklyn Law School for inviting me today. I think this is a great opportunity to talk about what's a really important piece of federal legislation that I think deserves probably more attention than it's getting right now in the popular press and with IP folks. So I think this is a really important conference. My background, I graduated from the University of Pennsylvania Law School. After that, I clerked for a federal judge for a year, and then I practiced IP litigation at the law firm of Sidley and Austin in Chicago. My primary practice was patent and trade secret litigation, so I have experience in both federal and state court dealing with trade secret cases. A few years ago, I ended up making the jump to academia, and I'm now at Washington and Lee University School of Law, where I teach classes on patent law, intellectual property, as well as civil procedure and property law. So I kind of have a little bit of a background of both some of the practical aspects as well as some of the more, perhaps the more academic side to hopefully bring to this discussion. And to answer Paul's first question, he'd asked, what's a trade secret? The definition is pretty easy under the Uniform Trade Secrets Act, which is adopted by 47 states. Really three parts: information, and it includes, there's a fairly long list of things that a non-exclusive list of things that could qualify as information protectable as a trade secret, including a process, formulas, business information, and the like. Second, it has to be valuable to one's business because it is not generally known or readily ascertainable. Again, example of reverse engineering is one way to ascertain something. And finally, it has to be the subject of reasonable efforts under the circumstances to keep that information secret. Now, that's the UTSA. Many UTSA jurisdictions also look to the former restatement first of torts, which listed 6 different factors to look at to help guide this inquiry, including the extent to which the information is known outside the trade secret holder's business, the extent which is known within that particular owner's business, including how many employees, the extent of measures taken to protect the trade secret, the value of the information to the business, and the ease or difficulty by which others could acquire or reverse engineer the information.
Great. Sure, Ted, do you want to tell us, or Mr. Schroeder, do you want to tell us a little bit about the legislation that you're currently working on?
Sure. Ted's fine.
Okay.
And I want to echo those thanks to Brooklyn Law School, to the Trade Secret Institute, and Paul, to you, and to the rest of the TSI fellows and Professor Beauchamp for putting this program together. I'm happy to be with you today. My name is Ted Schrader. I'm Chief Counsel for Senator Coons from Delaware. Senator Coons serves on the Judiciary Committee, and as his policy advisor on Judiciary Committee issues, I staff him on intellectual property, trade secret, patent issues as well. And it's in that role that I became involved with this issue and with the Defend Trade Secrets Act. So just give a little bit of background here on trade secrets, maybe stuff most of you already have a good idea of, but trade secrets are, I think, under the radar, but a vital piece of IP in America, and estimates are difficult to, I think, to come up with accuracy and precision, but some estimates have held that trade secret valuation is around $5 trillion in the U.S. economy, which is about the same as patents. And increasingly, they've been subject to theft and misappropriation in the interconnected economy, as Dean Allard mentioned, including the internet, thumb drives, and the like. Again, estimates are difficult because to evaluate the extent of the loss, an organization called CREATE, with Pamela Passman at the head, estimates that the losses are between 160 to $480 billion a year. Former NSA head Keith Alexander estimated them at about 250 billion. Other estimates are also in the hundreds of billions of dollars. So we're talking about a lot of loss from the American economy. A constituent from my senator's home state of Delaware, in a public case, had trade secrets stolen that were close to $1 billion in a single instance. A former employee went to a competitor with about $1 billion of trade secrets. This constituent can survive the loss of the trade secret, but as many smaller, medium-sized enterprises cannot. And we also see increasingly the threat is coming from overseas, not only in terms of cyber espionage, but also in terms of employee poaching. Employee poaching, I think, has always been the traditional form of trade secret theft and misappropriation, but we're now seeing more and more foreign sponsors of that employee poaching. In April of this year, an engineer at W.L. Gore, which is a Delaware, Maryland-based advanced materials engineering firm. They make Gore-Tex, they make a number of military tactical equipment. A former employee was arrested in possession of Gore's next-generation camouflage technology, with bags literally packed and a plane ticket in hand for Korea. In 2012, another public case with a Chinese national on her way to China was stopped and arrested at Chicago O'Hare with possession of over 1,000 of Motorola's trade secret documents, again on her way to China. So, those companies again can absorb this kind of loss, more or less, but small companies that because of reasons we'll probably get into later, that rely to a greater degree on trade secret protection, really cannot. So this is an issue of American competitiveness. This is an issue of critical importance for the manufacturing sector. Some of the jobs we care most about keeping in America to build a strong middle class. So when Senator Coons came to the Senate, he has a background in engineering, in chemistry, in manufacturing, and he asked stakeholders in this area, how can we help? We know that trade secret theft and misappropriation is a major national problem. We have a criminal law, the Economic Espionage Act, to deal with it. But federal prosecution resources are limited. In today's world, they're much more interested in money laundering and terrorism, as they should be, quite frankly. But despite the value of trade secret theft, last year we saw about 25 cases brought criminally at the federal level. On the civil enforcement side, which is where this bill is, trade secrets are unique amongst IP as the area of intellectual property that is left to state legislatures and in New York and Massachusetts, state judges to define the requirements for a trade secret, the misappropriation, cause of action for misappropriation, and what remedies are available. So after convening stakeholders, I think we immediately seized on the idea of creating a private right of action. Companies told us this could address 4 main shortcomings in the current law, patchwork of state causes of action. 1, lack of uniformity, caused uncertainty and compliance costs in drafting confidentiality policies. One of the issues is substantive difference between the law, but also especially again for small companies, there can be high compliance research costs in terms of just figuring out what the law is in one jurisdiction versus another. Number 2, procedural, the lack of access to federal courts can lead to delays, difficulties in service of process, and access to witnesses. Number 3, the lack of the ability of state laws and procedures to respond to exigent threats. The 2 cases of foreign nationals caught at the airport are 2 examples, but as we know from the losses in trade secret theft nationally each year, there are probably many more that are not arrested. And finally, the patchwork of inconsistent state laws made it difficult for our trade negotiators to argue for increased protections abroad in bilateral and multilateral treaty and trade agreement negotiations. So working with the industry, we came up with a bill that we think makes substantive progress on all 4 areas, and it is the Defend Trade Secrets Act, which my boss co-sponsored with Senator Hatch. So the bill will create a federal private right of action for trade secret misappropriation, giving companies the right to go to federal court for trade secret theft under a single uniform cause of action. And to address the threat posed by trade secrets in flight, the bill contains a powerful and unique in trade secret law ex parte injunctive remedy. So in cases where a employer's or a company's trade secret is stolen, and that company can show to the court that the misappropriator is not likely to heed a traditional injunctive remedy like a TRO, that company can go to court, can get seizure ordered of the evidence, and in order to prevent the trade secret from disseminating into the world and out of control, out of the owner's control. So speaking a little more about this ex parte, because it is, you find it in the Lanham Act. Ours is a little bit of a twist on that. And we wanted to really make sure that the ex parte remedy, we want to be mindful for possible adverse effects that could be caused by abuse of this ex parte remedy. So in addition to the Lanham Act procedures, we include a language to minimize harm to third parties, require the court to take that into account, including damages, including attorney's fees, which include attorney's fees for wrongful seizure under the ex parte provision. And we wanted to make sure that the party would have meaningful recourse against a wrongful seizure, so we required a bond. Introduced the bill in April, and we began working with House partners led by Representative Holding from North Carolina, very close to where I grew up, and Representative Nadler from New York, very close to us now. We took a little bit of further input from industry, from some of the internet companies, from some of the public civil society, to further tighten the seizure language. So right now we have a seizure language we feel really good about. You can actually find it in the Trade Secret Protection Act over in the House. And it clarifies that ex parte relief is only can be obtained against the misappropriator, not against a third party. Requires courts to leave a non-misappropriator's business intact, including third-party customers of a non-misappropriator who might be in possession of the trade secret. And most importantly, I think we clarified that this ex parte remedy will only be available if the party seeking the ex parte order can demonstrate that the party against whom the order will be instituted would evade a TRO. So I think that the final piece really helps kind of button down the potential for abuse. House Judiciary Committee unanimously approved their bill in September. We're not likely in the Senate to see any more significant legislative action on anything other than maybe the National Defense Authorization and some spending bills, but in the new Congress, I think we're poised to reintroduce and move forward probably in 2015. So.
My name is Ira Levy. As Paul mentioned, I'm a partner with the New York office of Goodwin Proctor in the intellectual property litigation practice, and I've been litigating IP cases, patent, trademark, copyright, trade secret, false advertising, and the like for a little more than 25 years now. And I guess one of the challenges of going third is these two gentlemen have pretty much said most of the introductory material, and it really brought us up to speed. But I guess what I could add to really where we stand today is a little bit of a view of the trenches today, day in and day out, advising clients, being in court, trying to litigate these cases. And I think in part I maybe should have sat between them because Chris is really on one side of this debate. I think we'll find Ted is on the other side of the debate. But I actually am on the right place, so I tend to be on Ted's side of the debate. I think that there is a need for a federal law that helps our clients and helps them protect their trade secrets and helps them bring their cases in federal court. It helps generate really a unified federal jurisdiction on trade secret issues. And we're going to really drill deep into a number of these issues. And while the UTSA Uniform Trade Secret Act in 47 states has given some degree of uniformity, it's not the same way we see uniformity as we do in the federal law. It's not the same way we see uniformity in the patent law or in the trademark law or in the copyright law. While the definitions generally apply in many of the states, I think one of Ted's points really resonated with me, and that's the compliance cost, the planning cost, and the business cost. You sit with a client that has multi-state operations, and there are subtleties, and that becomes a challenge. There are subtle needs to conform their practices on perhaps a state-by-state basis. There's a lack of consistency. One of the significant issues we'll talk about is statute of limitations, for example. Under the Uniform Trade Secret Act, the statute of limitations are all over the place. A national federal uniform statute of limitations in this area would be extraordinarily helpful. The steps you have to take to reasonably protect your trade secret, again, it's at the margins, but it still varies in the margins, and it varies in a way that it comes with a cost to our clients and a cost to the business. And really the other and the last part of it, and I don't want to drill down at this point yet into the ex parte seizures, there are some problems with the bill, and I completely agree with some of the criticisms that have been leveled against it, and I think it needs some work, but it's also still at the early stages. But what we find is there are situations where, recent example was a competitive intelligence operation that we were addressing that we think, and our client thinks, may have gone too far. We're dealing with actors in Germany, in Canada, in California, in Pennsylvania, New York, and I believe there were 1 or 2 other states involved. And dealing with the patchwork, did the activity in Indiana constituted a misappropriation of trade secrets? The activity in California, it was directed from Germany. Can we get jurisdiction over them in a New York state court or in a California state court? And really the ability to counsel and advise our clients and to effectively get relief for them under a unified system, and a system that ultimately is in other areas will ultimately harmonize in a way that the state law hasn't, I think will be of great value and great importance to the economy.
Great. So I think actually, Mr. Levy, you just answered the first question, which is why is uniformity in trade secret law important, and how important is it? So let's move on to the second question here. And so as was already mentioned, the Uniform Trade Secrets Act has been adopted in 47 out of the 50 states over the course of the past 20 years. And one of the goals of drafting the UTSA was to harmonize standards and create a more uniform statutory framework for trade secret law. Why is the federal legislation, or the DTSA, a better approach to uniformity than the UTSA?
I'll take the first track at that. As a attempt to bring true uniformity to trade secret law, the UTSA is a partial success at best. I think most telling is Section 8 of the UTSA reads, "This act shall be applied and construed to make uniform the law among the states enacting it." And significant jurisdictions have left that provision out of the UTSA. So, Pennsylvania, North Carolina, Illinois, they all don't have it. These are put together as a pretty significant chunk of GDP. So, there are, I think the differences themselves get sort of pretty technical. What can be an improper mean? What does improper means? What are the rights of a party who innocently acquires a trade secret? It's very different in Illinois than it is in Alabama, in California. So, but basically what this comes down to is a uniform federal court through the Supreme Court driving to agreement versus 50 silos that are just coming up with their own rules.
And from Chris will give you the
No, go.
report on this
You can
one.
go ahead, then I'll respond.
And again, we look at this from a substantive perspective and from a procedural perspective. And also, in my view, I tend to look at it from a macro perspective and a micro perspective. How is it going to apply on a case-to-case basis versus how is the case law going to develop over time? But from a procedural perspective, one of the big challenges when you're drafting your complaint is how much are you going to say in your complaint? How much do you have to say in your complaint? One of the challenges in the individual implementations is, for example, you have a statute in California that says you must disclose your trade secret with sufficient particularity, and I'm paraphrasing, in order even to begin to take discovery of the defendant in the case. Some states are less strict about that, some states are more strict about that. So, some who have commented and critiqued the California law said you basically have to disclose your trade secret to the defendant before you can start taking discovery of the defendant as to whether or not they've appropriated your trade secret or not. And again, I think that a national perspective developing on that, and again, we're anticipating the challenges. For example, in patent law, we have local patent rules that have sprung up in more jurisdictions than I can keep track of anymore. We've had them here in New York, you've got them in Western District of Pennsylvania, and New Jersey. Their judges have their own individual rules of practice. But again, I think that it's more manageable and more predictable for clients to be able to look at a situation in the districts within the 50 federal courts and Washington, D.C., 50 states and Washington, D.C., and look at the procedural rules that develop there, than trying to really focus on the peculiarities of how those laws are going to be applied on a state-by-state and on a local state court basis. So this substantive, this procedural predictability is going to be very valuable. In New York, for example, there's a fight going on right now in a case before Judge Harris in Westchester, and it's going back and forth with letters and motions as to whether or not, again, the complaint is sufficiently identified the trade secrets at issue so that discovery could even begin. And they're months into the case, a lot of money has been spent. I've had a case in California that's been going up and down state and federal court on remand and cause of action being knocked out. What happens is almost automatically you file a trade secret complaint in California State Court, you get a demurrer saying you have not sufficiently identified the trade secrets, I can't answer, you've not pleaded them. I think if we were applying the Iqbal standard and the Twombly standard to sufficiency of pleadings and particularity of pleadings, we may again develop more of a national uniform standard that we could operate and advise our clients against.
Okay, a lot to respond to. Obviously, since I wrote the article, The Case Against Federalizing Trade Secrecy, I take a bit of a different view on this. But I want to break this. I want to break this down, I think, into three separate questions here. I think the first question is a descriptive question: is trade secret law generally consistent? I think on the big principles it is. In fact, the Federal Circuit agrees with me. In a 2011 case called Tian Rui, panel actually said we find trade secrets law to be generally consistent. This is actually dealt with Section 337 International Trade Commission action, but it looked at, one of the things it looked at was what trade secret law to apply, and it said, well, we can essentially create our own federal law in this limited Section 337 context because the principles are generally similar among all the states. And I think that's generally true if you look at sort of the big picture aspects. One, whether a trade secret, what are the requirements for it? Well, both the UTSA, all the UTSA jurisdictions in the restatement agree that it has to have value because it's not widely known by others in that particular business, and that the holder must take at least some efforts to keep that secret. Now, how much efforts are going to be going to satisfy that requirement, again, are fact specific, but there's no doubt that you at least have to have some value because it's not known by others, and that there's some reasonable steps to keep it secret. Again, UTSA, the second issue about misappropriation, both the UTSA and the restatement focus very heavily on what is considered improper means for acquiring a trade secret or using or disclosing a trade secret that was originally acquired by improper means. And in many of the hypotheticals that I've heard, both here and elsewhere, arguing in favor of federal trade secrets bill, they're pretty clear-cut examples that would fall under any state's definition of what would be misappropriation. For example, the employee, he walks off with a batch of highly sensitive technical information or a customer list and is sitting on the tarmac at JFK waiting to go somewhere else. I think every single jurisdiction, UTSA, restatement or otherwise, is going to find that that's going to, if that information is being taken and then going to be used by somebody else, that's going to qualify as an act of misappropriation. So I think there's pretty widespread agreement on the fundamentals of that aspect. And then finally, the remedial aspects. The general principle in all the states that have adopted the UTSA as well as restatement in other jurisdictions, we have injunctive relief going forward. If your trade secret's been taken by somebody, you can go get injunctive relief to prevent future use or misappropriation or disclosure by others, as well as damages for past conduct. The second question, I think, going from the descriptive question, is trade secrets law generally uniform? Is this a desirable thing, what we call, I guess, in academics? Is this kind of a normative question? Is this a good or bad thing? I think in general, yes, uniformity is a good thing, but I think there also should be some level of play in the joints. In particular, what I mean by that is I think there should be some level of state's ability to experiment with the scope and the particular procedures that we'll use to protect trade secrets. I think a high degree of difference would be a bad thing. It would lead to forum shopping and uncertainty, but a limited amount of variation can actually be beneficial in the long run. And those of you who, for example, who have read constitutional law, for the students in the audience who may have read or going to read at some point Justice Brandeis's opinion in New State Ice, which talks about states as laboratories of experimentation, right? We give states authority in a variety of areas to experiment with things like education and other policies. And I think that states can use trade secrets law, and in some limited respects have already used trade secrets law to help promote certain industries that they see as valuable. And so let me give you 2 examples. So one area in which trade secret protection is particularly valuable is the pharmaceutical industries and biotechnology. Many early stage products, they have a compound or something they think might be potentially beneficial, have some pharmaceutical application to treat patients, but they're not quite sure whether it's going to be a safe and effective drug. And so they will engage in early stage trials to determine the safety, subsequent trials to determine whether it's effective or not. And that's really important because that information is held as a trade secret before they can even apply for a patent, right? To teach patent law, one of the things we tell, part of the Patent Act is you have to prove that your product has utility, right? That it actually does something useful in the real world. And that may not be the case at the very beginning stages of research. You have a compound that you think might show some promise, but you don't really have any data to back that up. So trade secrets are particularly important for pharma, biotech, and we see states, for example, like Massachusetts, that have recognized in the past the inevitable disclosure doctrine to prevent people from walking off from one employee to go to a competitor to take that information with them. A counterexample, one area that's fairly well recognized in which there's a high degree of employee mobility is the computer software industry, right? Think Silicon Valley. You've got firms that are established. You have people who leave the firm, start their own new companies. In some cases, will go from one competitor to another. And this high degree of worker mobility is generally viewed to be economically desirable because there's a high degree of collaboration and sharing in the computer software industry. And California does not recognize what we call the inevitable disclosure doctrine that would prevent people from leaving their employer and going to work for someone else or just set up their own business in competition with their former employer. And I guess one of my concerns is that a federal law might actually prevent this from happening. If there's a federal law that is construed to have an inevitable disclosure doctrine that applies throughout the country, it would dramatically limit states' ability to engage in this type of limited experimentation. And I guess the third point to talk about is the Defend Trade Secrets Act, or its counterpart in the House, the Trade Secrets Protection Act, will it actually achieve this desired goal of uniformity that we at least, I think, all in some degree think that there should be some agreement on the basic principles of trade secrecy. I think, hopefully not taking too much time up, but I think there's 3 main reasons why, even though it might seem counterintuitive at first glance to say, well, we have a federal law that's going to apply nationwide, wouldn't that promote uniformity? I think there's actually 3 good reasons why it might not actually do that. And the first one is the lack of preemption, which hasn't yet been mentioned. And so both the Defend Trade Secrets Act and the Trade Secret Protection Act do not preempt other federal criminal laws or any state laws governing trade secrecy. And so what this means is that we'll have a federal regime, if the Defend Trade Secret Act is passed, that exists in parallel with 50 other state regimes. And so essentially we have 51 separate sovereigns who are interpreting their own version of the UTSA, or again, the DTSA is very substantively similar to the UTSA, interpreting that language perhaps differently. And so, and states can't review federal decisions about what federal law means, and vice versa. Federal courts can't review the final say what a state Supreme Court says about what state law means. So it actually introduces the possibility we'll have less uniformity rather than more. The second is that the UTSA and the DTSA are written in very broad terms, right? We talk about concepts like what does improper means, what are reasonable efforts to keep information secret. Those are fairly broad concepts, right? They're very context specific. Federal courts, if a new statute is passed, will have to figure out how do we interpret the language in the DTSA, what's improper means in the DTSA. Is it different from what state law is? Which state, if we're looking at state law, which state law will we look at? So that's one area of which there can be some disuniformity as well with the federal law. And even with similar statutory language I mentioned, there may be different interpretations of a federal statute versus a state statute. This creates the kind of situation that we saw for those of you who've taken civil procedure, since I teach civil procedure. You may have heard about this thing called the Erie Doctrine. I guess I subject my students to the Erie Doctrine for a couple of weeks in civil procedure, right? But think about what happened, what the state of the law was like before Erie, right? We had a general federal common law in a variety of areas, including torts like negligence, and we had state laws, but they differed, right? There were some different interpretations, even though there was some agreement on the basic principles, and that created rampant forum shopping between federal and state courts for what was the more favorable precedent. Another example of where a federal law has not created, well, at least perhaps a little better now, but it did not initially create uniformity was the Patent Act. There's a period of time between the passage of the 1952 Patent Act and the creation of the Federal Circuit, 30-year window in which the different circuit courts applied the exact same statute in quite different ways, to the point where it was well known that certain circuits were very hostile to patents, were highly likely to find patents to be invalid or not infringed, and other circuits were much more friendly to patents. And there was rampant forum shopping at that time. And there's still some degree of forum shopping today, even with a federal circuit that is meant to interpret this statute for all and apply it for all district courts throughout the country. The second reason why I think that there's possibility for disuniformity of the federal law, the trade secret law as it currently exists is inherently intertwined with state law. If we think about things like the scope and enforceability of non-compete and non-disclosure agreements, and what fiduciary duties that a former employee has to their former employer, those particular doctrines are governed by state law, and breach of those can be considered improper means. If we have a federal law, what source of authority will it turn to interpret, to use these kind of doctrines? Will essentially create a federal common law in these areas, or will it turn to a particular state law? And finally, the DTSA does have some variations with the UTSA because it permits, in addition to essentially substantively adopting the UTSA, it also permits civil claims under the Economic Espionage Act, which are both more stringent in some ways and less stringent in others. One way in which it's more stringent is it requires that the misappropriator's bad intent must be proven by the trade secret holder. One way in which it perhaps is less stringent is there's no express exemption for reverse engineering in the EEA. Also, there's a longer statute of limitations proposed for the UTSA. It'd be 5 years as opposed to 3 for most UTSA jurisdictions. So, apologize for sort of listing those big 3 things I wanted to kind of cover and think they're all pertinent to what was just talked about.
So, Professor Seaman, you just listed 3 main reasons or critiques of preemption for the UTS or the DTSA, and I wanted to turn it over to Mr. Schroeder and ask, why does the DTSA choose not to preempt state common law claims, unlike the UTSA?
Well, the simple answer is what the bill sponsors are trying to do is to create a floor. Innovation rights are different. They're not contract rights. They're inherently national. They're not necessarily tied to physical goods or even physical places. It's information, and what rights do you have to exclude other people from using that information? You go back to the founding of the country, and patents and trademarks, or patents and copyrights, excuse me, are listed in there, but not trademarks. Trademarks evolved as a matter of common law later, and then were federalized. And I think we see the same progression going on in trade secrets because they arose after trademark. And I would agree generally, and I think most of the folks who I spoke to would agree with Professor Seaman descriptively about the uniformity, generally speaking, in trade secret law. I think under the restatement, generally, we had a great deal of convergence. So the whole purpose of the Uniform Law Commission and the Uniform Trade Secret Act, though, was to drive that, if it's going to be basically uniform, we've got a national, national interest here, a huge amount of the economy, to drive them towards actual uniformity. And so that the UTSA process adopted, and as it's played out, it's failed to achieve exactly that. I think it's created less uniformity, but uniformity still exists. So given the nature of innovation rights in an economy, in the United States constitutional system, why not create a baseline? I mean, I think it creates more predictability. You remove these, you remove these transaction costs to some extent. I just, and the non-preemption, I think, is just, it's a desire to do what we can do. This is going to be a consensus bill if it manages to make it into law, and I think it's easier to drive consensus around that. I want to speak a little bit to the sort of divergence of law, foreign shopping. I mean, if this bill were to become law, trade secrets would not be unique amongst rights that are recognized both under the federal law and under state law. Unfair competition, antitrust, a whole host, consumer fraud, a whole host of issues exist under both state law and federal law. And I don't think it's caused the sort of pre-Erie problems that were alluded to.
Mr. Levy, do you have anything to add to address, I think it was the second critique that Professor Seaman brought up on the ambiguities of the statutory language in the DTSA? Do you find that the DTSA's language is ambiguous, or do you have anything to comment on the other critiques that were given by Professor Seaman?
On the specific point of ambiguity, no, I don't. I think it's as well or as poorly drafted as any other federal statute. What's the old description? What's a camel? A horse that was built by a committee. I mean, ultimately, and I think as Ted points out, the preemption issue, it sounds like it's a compromise point that felt may be necessary, and I'm putting words in your mouth, felt may be necessary in order to gain passage, in order to gain support around the bill. Do I think preemption would perhaps be better? I think perhaps it would, but I think that the sacrificing preemption on the altar of gaining the ability to get uniformity, and I do think uniformity or harmonization is an important point, and I think that a path to harmonization is more direct when you're dealing with the federal system. We talk about patent cases. Even with a single federal appellate court, we saw the Supreme Court taking, I think last year, 10% of its docket was patent cases. So even within a single appellate federal court, while you still have this uniformity, you've got the Supreme Court saying, we'll address that. Whether or not the results of their cases are actually effectively addressing the problem or making it worse is perhaps a topic for a separate institute on a separate day. But even on the trademark side, we've got disparate circuits reaching disparate conclusions about issues from a single legislative scheme. But yet again, the Supreme Court, in December 2nd, they're hearing the D&B Hargis case to take up an issue that has split the circuits about what you look at what the Trademark Trial and Appeal Board does and how that impacts on the district courts. So again, I think that the pathway to get harmonization uniformity is a lot quicker in a federalized system than it is in a state-by-state system.
Do any of you have anything else to add on uniformity before we move on to the next topic?
Just one brief one. I promise I'll keep this one brief in contrast to my last one. So I think Ted's point about the federal law creating a floor is a really worthwhile point to explore, because it's going to, I think, relate to what I had just talked about state experimentation. If the federal statute sets a particular bar, right, states could, as a matter of their own law, go have less protection, but effectively it'll be meaningless because whoever the trade secret holder is will go for the stronger substantive law. So that's one, again, sort of going back to the inevitable disclosure example. If there's a federal law in which threatened misappropriation is interpreted to mean the inevitable disclosure, and I guess I'm saying that phrase, I'm not sure that all the students necessarily know exactly what inevitable disclosure is. It's a doctrine that says if you hold an employer's trade secret information and by going to a new firm that you will inevitably end up using it because you simply can't segregate it out of your brain, that you will not be allowed to take that job either permanently or for some limited period of time in which your trade secret information is no longer valuable. And that obviously has some significant consequences for worker mobility. And so it essentially would allow flexibility, but only in one direction, going upwards. It's creating stronger trade secret protection. And I think really that's what we've seen as the history of trademark law with the creation of the Lanham Act. And I'll give dilution as a brief example of that. At the time the Lanham Act was adopted, no states recognized dilution as a cause of action in trademark law. Subsequently, a number of states did adopt it, starting with Massachusetts, and it was about a 50-50 split at the state level, at which at a point the Congress again stepped in and said we need to have uniformity. Let's create a federal remedy for dilution, which again was strengthened then a number of years later by eliminating the actual confusion requirement. And so my concern is somewhat with what's going on now, but sort of what happens 20, 30, 40 years down the road. We see inevitable one-way ratcheting up of trade secret protection because the federal law becomes so prominent.
I think that's basically fair. On the inevitable disclosure point, I would just point out, I believe the inevitable disclosure among the states is the minority view, and I would expect it not to be taken up as part of a federalization. And just brief explanation, the idea of inevitable disclosure is that you can be guilty of misappropriating a trade secret before you misappropriate it. because your knowledge is such that you would have to misappropriate it if you would go to a competitor. And that's the minority view, I think, although some significant jurisdictions do adopt it.
So for the next subject, I figured we'd briefly get into some of the more practical impacts of this law and talk about some real-world scenarios. So if you are an IP lawyer in New York and the baker with the secret recipe for the cronut comes to you for advice on protecting her trade secret, would your advice change substantially if the DTSA were to pass? And more generally, how would federal trade secret legislation impact businesses on a daily basis?
And I've been warned he's turning to me first as the IP lawyer in New York. I mean, I think the practical reality is if you're talking about day one of the passage of the DTSA, again, and this is that macro-micro thing. I think in a macro sense, your advice really is not going to change on day one. You're going to be advising your client. You need to want to identify and specify what your trade secrets are. What is it that adds value, that is not known to competitors and not readily reverse engineerable? What steps are you taking in order to protect that? Do you have agreements with your employees? Are only those who need to know the recipe or the formula exposed to the formula? For example, if everyone in your shop bakes and your secret is in how you bake it and you've got to disclose it to everyone, you may have a problem regardless. Do you have the right employment contracts in place? Are you able to, no pun intended, bake the recipe into automated machinery, in which case no one really has to be knowledgeable in it except for yourself? So are you taking reasonable steps in order to protect it? You're going to look at the end product. You're going to say, is this reverse engineerable? And if it's reverse engineerable, is there anything we could do in order to build further, or again, bake further trade secret protection into the cronut? So I think that under the legislation, you're still going to be talking about pretty much the same standard in order to identify your trade secrets, take a reasonable step to protect the trade secrets. And again, I know, I don't want to jump ahead to the second question. I think the differences may come if there is a potential theft of those trade secrets and how you may react differently under DTSA.
I think just one brief thing to add to that, the difference is if you become successful with your particular brand of cronut and you've undertaken this examination with IRA and you know what the proper methods are to do and you want to expand to Hoboken or wherever, you don't have to do it again. You can just take those same precautions over with you and you know that they're going to be protected.
This is the first I'd heard of a cronut. We don't have those in Lexington, Virginia. So.
Well, that's the problem. We can't figure out.
We have to figure out how to get it.
And so she's scared to take it out of state.
I am planning on stopping by the Dominique Ansel Bakery. That's where the cronut.
Mm-hmm.
Take some of those back with me, so I hope I'm not misappropriating. Tracy, we're taking the donuts across state borders.
Yeah, I'd say it's allowed to take them in.
So the second question would be, if the cronut baker now came to you claiming that her secret recipe had been stolen, what would your approach be to litigation today, and how would it change under the DTSA?
Well, again, presuming the DTSA is implemented in, the form that, this bill is currently in, much to the probably chagrin of Chris, your first thing you do is you're quickly examining if the ex parte seizure order is appropriate and is available under the statute as passed and under the law as it developed. Is the use of these trade secrets and the potential harm sufficiently imminent that an ex parte seizure is necessary to prevent the destruction of evidence, to prevent the removal of product, to prevent a further disclosure that could cause. And this is one of the challenges. This is why, if used properly and if interpreted by the courts properly, the value of the trade secret, you have to remember, is lost once it is no longer a trade secret. And maybe you could get a remedy, but once the formula for Kentucky Fried Chicken or the recipe for Coca-Cola is published in the newspaper, posted on the internet, it is no longer a trade secret. Because once everyone knows, you can't put the genie back in the bottle. And so in certain circumstances, if there's an ability to judicially stop the genie from getting out of the bottle, you're going to want to be in a position to take advantage of that. You're going to want to need to move quickly. We do it in trademark cases, we do it in patent cases. We're seeking TROs. On the trademark side, I cut my teeth, doing raids in Chinatown, in back of warehouses where there were T-shirts that were in boxes with Playboy logos and Playboy emblems on them, that we knew were counterfeit. You were able to work with the U.S. Marshals. You were able to get ex parte seizure orders. And that was a very effective and valuable method in protecting the integrity of the brand, if you think the brand has integrity. I'm not going to get into that discussion. But again, okay, Timberland clothing, we used to do it also. But again, the practical reality is that's a very valuable arrow to have in your quiver in the case of a theft or misappropriation of your trade secret. Looking beyond just the ex parte, what we'd be doing is, again, right now we'd be looking at state court. I think even on the TSI website, they have a posting about the J. Crew case, and I don't remember which one of the fellows wrote the little analysis, but they highlight the interesting point. They don't use the phrase trade secret anywhere in this complaint, which sounds in misappropriation of trade secrets. An employee apparently took designs that were not yet going to market, took them over to Bonobo's Jeans, and they talk about misappropriation, they talk about all these other causes of action under state law. They don't use the phrase trade secret. Here, in this case, if we have the DTSA available to us, I know that we're going down to Foley Square, or we're going up to White Plains, or we're going out to Uniondale. We're going to the appropriate court. We know we have papers that are, set on basically not quite established, but hopefully well-developed and continuing to develop set of law, and you're able to move quickly, you're able to move efficiently, you're able to move effectively. Once you're into this litigation, you're able to take discovery as broadly as you need to using Rule 45 and using the subpoena power of the courts. You're able to look for actors in different parts of the country. You're able to get them in under the Uniform Discovery Rules. Ultimately, and I don't think this would be the case, but if you found out that this misappropriation took place 4 years ago, if you're under the DTSA, you're fine because you've got the 5-year statute of limitations. If you don't have the DTSA available, you may be out of luck because of statute of limitations. Again, with Cronuts, if they're out there, it's not going to take 4 years to then take the trade secret and then be able to really manufacture the Cronut. But again, just to take that example out further. So I think that, in the practical reality versus going to commercial part in state supreme and really trying to move quickly, and while the court is capable of moving quickly, I would just find that it'd be more effective to guide my client, get quick remedies, and get effective relief if I was able to deal under a federal regime.
Don't have anything to add to that.
Okay. Anything to add?
Just a couple of brief things. So I guess, and I think it's a good question, what would I do? I think the first question I'd ask is who stole it? And that I think might significantly influence what happens next. If it is somebody who, for example, lives in New Jersey and wants to set up a competing shop in New Jersey, you can get into federal court already. You've got diversity jurisdiction. I know that's one of the goals of the act is to get into federal court. But there's already quite a few situations, and particularly the most common examples that I've heard about what this bill is meant to address, theft of trade secrets from companies and taking that information overseas and using it there. But that's a very common situation in which under 1332 you can already get into federal court. So I guess I'd first ask who took it, because that would significantly influence. Then second, where can I go to sue about it? And then the third category, what kind of relief am I seeking? And currently, we already have a pretty diverse toolbox. You can get temporary restraining orders in both federal and state court, preliminary injunctions. And I guess the one thing I've not sort of fully heard as an explanation as to why those existing tools aren't adequate. Because certainly you can go and get those things now, and what an ex parte does above and beyond that. Ex parte seizure, sorry.
We just kind of want to transition into the next part of the discussion, I think. I can...
Sure. The next subject is the ex parte hearings and also the availability of a federal forum. So if you want to start off, Mr. Schroeder.
I think that when you're talking about an employee who has a sponsored theft of trade secret, has a ticket to go on the train to JFK and then on the airplane to Korea, they're not going to listen to your TRO. They're just not going to do it. And so companies tell me, and these are the ones that are public, but the ones that are not public you're never going to hear about, because the trade secret itself is so sensitive, and both from a stock price perspective and from a competitive perspective. But this happens relatively frequently. Companies have sophisticated, I think the sophisticated companies have developed sophisticated information management technology, management systems where they can track employees when they're leaving. What do they do after they give notice to leave? If they're terminated, what do they do? What are they likely to have information that is trade secret? Should they have that information? they can have a pretty good idea if somebody is about to run off with some trade secret information. And when they learn that, they need to be able to go to court and stop that from happening. Because once that employee gets on the plane overseas, there's nothing that can be done about it. One thing, the trade secret enters the wild and it's no longer a trade secret, that could happen. The other thing that could happen is now you're trying to enforce a judgment, as our client was in Delaware, now you're trying to enforce a judgment against a Korean company, and good luck enforcing that award in Korea. Good luck not being retaliated against if you try and enforce that award in Korea. And so, really, I think the ex parte piece is the major innovation of this bill. It's the one, we talk about the CFAA also provides you asked how is it stolen? Who stole it? How is it stolen? All these things, there's a number of questions you could ask that are going to get you to federal court, and once you get to federal court and you research the law, it's going to be about the same no matter where it came from. Now that process, I think, is too cumbersome, too expensive, and we can streamline it, and that's a large part of what this bill does. But really the ex parte piece, the threats that companies are facing today, it's really necessary. And I think if you look at the folks who have supported this legislation on the industry side, that really kind of bears itself out.
Just to rewind one sec. So an ex parte hearing under the DTSA would be, you would have the option of going to a judge, and without the other party being aware or present, you could have a hearing and get a injunction or restraining order to actually seize the alleged misappropriators' servers or goods or whatever it may be that you need to lock down in order to prevent further damage.
Yeah, and I think if you go through the text of the legislation, either on the Defend Trade Secret side or the Trade Secret Protection Act on the House side, you're going to find that servers are not likely to be able to get, because of the protections that are in there for third party and the bonding, quite frankly. But what you're really talking about are thumb drives, our file folders, our personal computers. I think primarily ex-employees are going to have at their home or in their person, and you don't want to rely on them to abide by a TRO, even though you could get one. You want a U.S. Marshal to show up, you want an FBI or agent to show up, to take that document, to take it in safekeeping with the court, and then there'll be an opportunity to be heard, and if you ended up asking for this thing improperly, you're going to have to pay some damages and presumptively attorney's fees to the party who's wrongfully seized.
And I think, there are important protections that are baked into the draft act. For example, the materials that are seized, they're in the custody of the court. You as the applicant, you as the petitioner requesting the ex parte seizure, you're not getting possession of this material. The court's holding it until future hearings and until time it can be managed, properly through discovery. You've got to make, there are procedures and plans in place where you've got to minimize the interruption, I think as Ted was saying, on a third party who may be an indirect beneficiary of the use of the trade secret, their material. The courts are very sensitive to protecting that, or at least the courts will be sensitive to protecting that under the act as currently drafted. And I think the other part of it is, there were abuses under the Lanham Act seizure orders years ago. There were attorneys some who were sanctioned for exceeding the scope of their authority under seizure orders, were acting without the benefit of U.S. Marshals. But one of the things that the Act does, which I think is potentially very effective, by now we do have a history of using the Lanham Act for seizures, and what the Act currently does is it says, use the language of the Lanham Act, and where it says counterfeit, put in the language misappropriated trade secret. So we're really putting it into a long and well-established existing scheme, or what the Act purports to do is put it into a long and well-established existing scheme that has a history of application, interpretation by the court. And so it's not as though we're starting with a blank slate. And just to comment and respond to one thing Chris has said, there are very effective methods that are currently out there. This is not a rampant problem that needs an immediate remedy. And I think the way I view the Defend Trade Secret Act is that these are well-needed improvements to a system that I think that in the long run will make the system better, and will make it, we'll address later whether or not this is a plaintiff's side or defendant's side act. But again, I think it will make it more predictable for all parties to the system and all parties to the process. And I think that it's got value in and of itself in doing that.
Really briefly, I think the Lanham Act analogy is actually quite revealing for two particular reasons. I think it helps show why using the ex parte seizure for the Lanham Act actually doesn't work quite as well for trade secrets. And one is the nature of the goods. For trademark, we're dealing with chattels, physical property, something that is marked with the good. For example, think about a T-shirt bearing the Nike logo and name coming in the United States. If somebody's making a knockoff version of that, you can intercept it at the border. In contrast, information is much more flexible, and there could be a tendency for trade secret holders to be overly aggressive with what they claim to be a trade secret. When I was in private practice, I had one case I worked on where the company was very aggressive about what it asserted in its plan as being a trade secret. It essentially said everything in the plan except the location of the men's bathroom was a trade secret. And so that could be one thing, that the information opens up a much larger door for things that could be misappropriated. The second is that it's easy to seize physical objects. Information, however, is much more difficult. And I know that the example of the flash drive has been used, but I think today it's really more likely we'll see that somebody will upload the information onto the cloud. And it'll be stored in servers in a variety of different locations. And the question will be, will this ex parte seizure, will you then have to go and raid or get orders to go into a variety of different servers to retrieve that information? So that's just one sort of.
And I would just, you know, if you don't, I would say no. I mean, I think no is an obvious answer, and I think sort of arguments that it's not are not credible. So we took the Lanham Act, and with the first draft of the legislation, we went with that, we referenced it. And these differences that Chris points out were raised to us by a number of the information-based companies that would conceivably be on the end of this seizure order. It's in the, I mean, I think you need to look to the Trade Secret Protection Act in the House, because just the way the legislative process works, if you don't, I mean, we haven't marked up the bill yet, so we haven't had a chance to release our new draft.
Right.
But we worked with the House partners in creating this HR 5233, which contains a modified seizure provision, which does not copy the Lanham Act wholesale. It spells out that the person against whom the seizure needs to be ordered has to be in this appropriator themselves. So the Dropbox, Google Drive will not be susceptible to a seizure. You have to show that the person against seizure will be ordered would evade the seizure order. So you would just get a TRO against Google. You would get a TRO against Dropbox. You would say, don't let anybody download from this account. And you would be, you know, that would be fine. There'd be no reason I think they wouldn't abide by that. I mean, finally, the bonding requirement, presumptive attorney's fees, punitive damages if sought in bad faith. And these, if you're talking about going into a internet company's server farm and trying to take something offline, even if you can demonstrate to the satisfaction of the court all of the other procedures are met, you're talking about billions of dollars potentially that you're going to be on the hook for if you shut down the major internet companies' worldwide operations. So, you know, I see these concerns. My boss sees these concerns. Other sponsors of legislation have seen these concerns. We've really tried hard, and I think we've gotten there. We've worked with the Internet Association. You know, I just don't think these worst-case scenarios are plausible at this point.
Well, and I appreciate that, because I was coming primarily of the DTSA as it's currently written, and I do feel that the TSPA in the House does provide some more protection, which I think is a commendable thing.
So
I don't know if we want the audience comment or wait till the end.
should we, sure, well, because this is, you know, a very big issue with the act, why don't we do some comments now, and then I do have a few more questions if we have time.
Thank you.
Do we, Professor, do we have mics? Do we have mics, I think?
Yeah, I'm loud enough. Dave Levine, I teach at Illinois University. I'm a visiting researcher at the Center for Information Technology Policy at Princeton. By way of disclosure, I've been an active opponent of the acts, and I generally agree with Professor Seaman. On this issue of seizure, Ted, and you and I chat about this a little bit, but I think it bears further discussion. You know, the language of the acts to me reads eerily similar to the Stop Online Piracy Act, the efforts of a few years ago to go after copyright infringement on the internet. And the concern about the use of this seizure power and remedy is not as much about what happens in the courtroom as much as what happens outside of it. And so I'm curious, and I'll ask Mr. Levy as well, although I haven't discussed it with you personally, how do you deal with the chilling effect that we've seen rampant in copyright, where the mere threat of litigation, regardless of its merit, regardless of whether it would have any success even under, and I agree with Chris, the better provisions in the TSPA, right? When we know that many of that will never see the inside of a courtroom.
Well, I think if those were concerns that still existed, we wouldn't have earned the agreement of some of the major companies that were involved in the SOPA debate. In fact, we've worked well with some of the companies that were on the Internet Blackout Day, who are actually supporters of the bill. You know, I just have to go back to the very high standard for granting the order and the punitive consequences of seeking something you're not entitled to under the order. You know, it's something to be aware of, and it's something to take very seriously, this idea of chilling abusive process, and remain open to ways we can make the bill better. But I think the group that we've worked with has come together to a pretty good product in the Trade Secret Protection Act.
And even though we talked about a bunch of other things at lunch, we didn't hit this one. I also think that in practical reality, I think that it's going to serve, I'll call it a deterrent effect, you may call it a chilling effect, but I think in practical reality, I think that applications for these types of orders may turn out to be very rare. Because I think that you're going to need a lot of specific information going in order to know what it is you're seizing, what it is you're shutting down. And given the timing and how quickly data flows, we talked about, again, the Lanham Act seizure counterfeit provision. You know, right now we're giving greater protection to a counterfeit t-shirt with a Nike logo than we are to a thumb drive with $1 billion trade secret on it. And I think that that's a problem with the system. But again, as far as the seizure order goes, you're going to have to be able to lay out for the judge where you need to go and what it is you want to do. And I think that there's going to be a lot of diligence involved in that. I wonder if the practical effect is you're going to have to do so much homework that by the time you're ready to move, what you're looking to grab may have moved already and may not even be accessible to you anymore. You may be following different procedures as it's about to get on the airplane. But I think that if you're worried about trying to grab what's going up into the cloud, and again, I'm thinking this through for the first time now, if you're trying to grab what's going up to the cloud, that's going to be pulled down, you know, somewhere else on the planet, maybe even before you could grab it by the time you've done your homework. So I know that this has become one of the headlines for the act because I think that when you have what you need and you're really in a position, it's going to be extraordinarily valuable remedy. But I think in practical application, it's going to be very, very difficult to implement.
And I think it is fair. I don't want to dominate the time, and I appreciate certainly the sincerity of the efforts. And as you know, Ted, I mean, I share the concern about the harms. It's the solution I'm concerned about. My concern, quite frankly, and this is going to sound rougher than I intended, is not Google's ability to defend itself. I'm concerned about a startup entity that doesn't have the resources to defend itself in court and will face a letter, right? And this is true in many practice areas, right? But the classic cease and desist letter, right, that operates an IP in ways that a large entity can handle quite well, and certainly, and Google and other large players are not under-resourced in that area, is one that I think requires significant concern. Certainly, it's a primary reason why I am opposed to the acts as written. And I have a follow-up, but I'll stop there. Thank you.
Okay.
I appreciate you. Pardon the interruption.
I would just point out the National Association of Jobs and Innovation, NAGI, which is a organization that exists to speak for the small, medium-sized enterprise practicing in trade secret, supports this bill. So I think it's a concern that might exist. On balance, I think they at least have made the decision that it's better than the status quo.
Because I also think that small startup company, if you spend any time in Silicon Valley, that small startup company is just as likely to be susceptible to their own co-founder, their own employee moving next door, getting off an airplane, another company. So they want this also.
Well, that goes back to Professor Siemens' questions about whether the law works. But I appreciate it. Thank you.
So earlier, Christopher and Ted were talking about the inevitable disclosure doctrine, and I think we're seeing evidence that it's increasingly problematic. Books like Talent Wants to Be Free showing how it actually can have a real economically deterrent effect to prevent human capital from moving from one company to another. So I was going to ask you about it in the draft, because the draft that I had seen didn't seem to speak to whether that doctrine was live. And what I found really most troubling was that, Ted, your comment was, well, it seems to be a minority view, so it probably wouldn't be adopted. And it seems to me that if you're trying to create a uniform rule to be applied to everyone, we should know what that rule is. So the question is there a possibility of putting in something concrete, specifying whether that doctrine is going to be live or not, and what side of that would you come down on?
Well, I think we're always welcoming of suggestions to make the bill better. I mean, I think you're kind of blinking at reality if you think you can write a law and then judges aren't going to interpret it, and it's not going to go off and become something slightly different than what you conceived of
But
it.
if you have a clear problem already that you know about, you may as well address it.
Yes, like us, we'd be certainly willing to entertain suggestions along those lines. I think, for instance, if the bill is going to speak to one side or the other, no bill will ever be passed that adopts the inevitable disclosure doctrine.
And so it should have it in there? Should you state, can you state it that it's not there? Are you hoping
Well,
that the judge picks it up?
I think it's something that was raised after the House process had played out, and we're certainly open to considering it, yes.
I would just
I was told that we're running short on time. Jeff Schwab, just a quick question. If there's no preemption and you have inevitable disclosure as part of a particular state that you're in, most cases are brought, you allege both your federal cause of action and under ancillary jurisdiction, your state cause of action. Those states that believe that that is an appropriate remedy might continue to use it. Is that correct?
Yes.
Should we wrap it up, or?
We'll have more questions, there's going to be a break, so you can go through your.
Okay, yeah, so feel free to ask your questions during the break. We're going to take 5-ish minutes to grab some coffee downstairs, and then we will be starting the second panel on startups and what they should know about trade secret law with moderated by Dia.
Thanks, Ted. That was